Good evening, ladies and gentlemen. This is the Municipality of Anchorage Board of Adjustment regularly scheduled meeting of April 28, 2017. Madam Clerk, would you call the roll, please?
Yes. Mr. Goodchild.
Here.
Mr. Stewart.
Here.
Mr. Adams.
Here. Thank you. All three of us are present and we are on the record. We have spent 2 long evenings discussing this case, passing motions, and reviewing and editing our decision in this case. And our faithful attorney has reworked it on the basis of her understanding of the changes that we made last night. And what you have in front of you right now is a draft. And my intention is that we go through the draft, paragraph by paragraph, and catch whatever changes may be necessary, and supplement it where we feel it is necessary to supplement or delete whatever. And when we are done with that we pass a motion adopting it. And once that adoption hopefully has then passed, what will happen is that the clerk's office will incorporate the changes that we have made and suggested, and I will then sign it. And what I will sign will be the version that we have approved tonight. There will be no changes to it. If there should be changes, we have to go back. Short of simply, a punctuation situation. Or if there's any material change, obviously I have to come back. Okay? So, having said that, I would like us to go through this one by paragraph. I think that's the easiest and the quickest to attend to this right now. And please speak up if you feel that there are changes necessary, and that also includes Ms. Tucker, who will undoubtedly have some comments on some of these issues. First whereas, any problem with the first whereas?
None.
Okay.
I do. On Northern Lights Boulevard, I'll capitalize Boulevard. And changes that you make here, I'll go ahead tonight, and so that the clerk has a clean draft.
Okay. That's fine. Second whereas.
Just one question, I guess, is we talked about this last night. If you remand something, by the fact you're remanding, it goes back. So do we need to say back? It's kind of a small matter, but
No, you don't need to say that. A remand is a remand.
So remand.
It's not a remand back. Where do you see that?
Oh, I'm on the 3rd paragraph.
Oh, you are jumping ahead.
I was in an accelerated classroom. Still with me.
All right. Any changes to the second whereas?
No.
No.
Mr.
So
Stewart?
you want me to
None.
strike back?
Just in the 3rd paragraph?
Right, in the third paragraph.
Wait a minute. We are at the second whereas.
My fault. I moved this up.
Okay. So no changes. Now we come to the third whereas.
And that's my back. Remanded to
Strike the word back.
Got it.
Any other changes to the third whereas?
None.
Seeing none. Before we talk about the fourth one, you know that Sears Roebuck sold its interest in the mall at some point to Seritage. And should we make mention of that?
I don't see that as particularly relevant, so I just, in the number 2 whereas, that's how it started there, but if you think that it's important.
Well, here's the reason why I'm saying that. When you look at the appeal, the appellee is listed as Seritage, I believe. And so I think we should take a look at
The resolution that, on which we are acting says Sears Roebuck.
But when you look at the appellee's brief, no, it doesn't give a name. Isn't that interesting? Nonetheless, I would like to insert a whereas.
And where in the record my concern about doing that is that you're opining on things that.
No, it's in the record somewhere that, and I think that is in the appellant's brief.
And if appellant doesn't have that quite right,
Well, the appellant does have it right. Because it simply is, the proceeding. The parties here. Appellee Heritage SRC Finance LLC is the owner of the property and the applicant for limited site plan approval, having acquired title from Sears Roebuck, which was the original applicant, and it refers to the record at page 185.
okay,
Yep. So page 185.
right, so that makes Heritage the
appellee.
appellee. I mean, that makes them the appellee, but it makes them the applicant on the application that Sears filed.
It's a substitute. Why don't we simply say,
Do you want a footnote someplace that says that refers to the record here, and just let the record speak for itself about that?
yeah, why don't you make a footnote after the second whereas?
In their letter,
And simply say, Heritage SRC Finance LLC is now the owner of the property, and in effect, the applicant for limited site plan approval, having acquired title from Sears Roebuck and Company.
Okay, Heritage SRC
C Finance LLC acquired title from Sears Roebuck and Company.
Well, it just says it's the current owner, so let's just.
The original applicant,
Just Heritage SRC Finance LLC is the current
owner.
owner of the property under review. And then you
Just-
cite to this record. I don't know that you want to make any additional conclusions.
No,
it says in that letter, they're saying Heritage is the proper owner and applicant in case 2014-0094, so they consider themselves an applicant. At the bottom of that second paragraph.
As a result of the July 7, 2015 sale and assumption, Heritage is the proper owner and applicant.
What do you have so far?
So far, I have Seritage SRC Finance LLC is the current owner of the property under review. By letter dated May 12, 2016, Seritage notified planning department
Of the change in ownership.
that Seritage is the applicant in case
In this case.
in this case.
Okay.
Okay, so we read that back. Seritage SRC Finance LLC is the current owner of the property under review. By letter dated May 12, 2016, Seritage notified the planning department that Seritage as proper owner is the applicant in the case. R185.
What is R125?
That's the
Record.
record citation, R.185.
Yeah.
Oh, okay. All right. Any problem with that? And that's a footnote to the second whereas. Okay, we had already discussed the third whereas. Fourth whereas,
We just need to add a before public hearing. Held a public hearing.
held a public hearing.
Thank you.
Next whereas, going to page 2, first whereas on that page. Presumably, Julia has checked the date. Yes, Julia?
I did.
Okay,
And
good.
that's-
No, that's fine. I really,
Good to check again, let's see.
no, that's fine.
It says 8/24, it still says
Okay.
8/24.
All right, next whereas,
Nothing here.
nothing there? Okay. Final whereas,
Is there a way that we can replace the 2 commas after 2017? Is that
make a semicolon.
grammatically?
Why don't you make a semicolon? And the same
So-
after April 27,
Right.
make semicolon.
After each year?
Yes. Now therefore. Okay. Now we come, and you will see that the way this is structured is, it says Roman numeral 1, review of Superior Court order, etc., etc. And when you, just by way of previewing it, if you turn to page 5, you will find that there's Roman numeral 2, and that's entitled findings, and then subsequently there's a decision, conclusion and decision. Okay? All right, let's look at the first paragraph of the review. Any problem so far?
I
Okay.
don't see.
Turn to page 3, end of quote.
In the quote, third line, I believe that specifically it says a proposal's economic benefits.
Give me a break. Tell me again.
Third line in the quote. before
Will
this
likely highlight a proposal's
economic.
economic benefits.
Yes.
Thank you.
I think you're right.
Okay. Anything else? Okay.
Not from here.
Then we come to the paragraph following that. Of the public hearing in the first line.
On the fourth line, end of the sentence or end of the line, it should say relating to the requirements in code, I think.
Relating
Although maybe relating the requirements is
to,
possible.
I think that's what was intended, Julia, wasn't
Yes,
it?
the two, and
Okay.
then back up on that first line, you wanted to say the Board of Adjustment notes that at the close
Of the public hearing.
Okay. And not at that at close of, we took out a lot of Ds last time, so.
Yeah, I understand. I made a notation here of the word holding here in the second to the last line of that paragraph. Are you referring to the court's ruling and holding?
Let's see, I'm gonna.
Is that what you're
look at
referring to?
the transcript and see what it says.
Page 88, line 16.
So, this is what the transcript says, and so it's more lines than that, but it says the Planning and Zoning Commission held a public hearing on June 13th, 2016, in which public testimony was heard. The hearing was postponed to July 11th as there was a question on the court ruling and the holding. The commission is directed tonight to review the petitioner's amended site plan application in its entirety for compliance with the code, old code,
Okay.
Title 21. And so I was aided in this, and I thought this was a good way of summarizing that by my cohort, Mr. Dean Gates's notes as he was upstairs typing away.
Okay, well, I must tell you, I find this, I would like to streamline this a little,
Okay?
was directed by the court to review. So scratch out ruling and holding.
Right, to review.
Okay, to review.
That's good.
Is that agreeable,
Yes,
Mr. Stewart? Okay.
yes, it is.
Anything else in that paragraph? No? Let's go.
Mr. Chair,
Yes,
would you be interested in me adding any comments about some, I noticed that there's not a period at the end of the site in the middle, and I think Title 21 should be capitalized. Do you want me to just keep track of those, and then those are the types of things that...
That's
Lisa
fine.
makes? Okay,
Yeah.
I'll keep track of those, I won't
Yes.
mention them.
okay, thank you. Let's go to the last paragraph on the page of page 3. changes regarding that paragraph? Mr. Stewart?
None.
Good. Julia? Anything? Okay, let's turn to page 4. Next paragraph.
Are you in the whole new paragraph now?
Yes,
Okay. I have a change.
where? What page?
It should,
You're not going back to page 3, are you?
no.
Okay, page 4, first full paragraph.
The Anchorage, it should read Anchorage Municipal Code of Regulations.
Yes, that's exactly right.
Oh,
Good catch.
well, Mrs. Stewart always catches these things, it seems to me. I've noticed that in the past.
I'm a repeat offender, I think.
No, the toothbrush that you're applying to this just is finer than the toothbrushes that the others here use.
Yeah, but we want to use this one.
Oh, absolutely. Okay. Anything else until we get to the end of the Fields case? Yes.
In that paragraph, we just made a change to, there's a site to 360, 655. The citation should be 360, 055.
That's a good catch.
Ooh,
360, what?
055. I just checked it.
Hold it.
I still don't have it.
On the second line, first full paragraph, there's reference to AMC 3.60.655.
Oh,
That should
okay.
be 055.
055, not 655. Thank you.
good catch.
Good catch. Now, how come your fine toothbrush didn't catch that?
Come on,
Bob?
we got it.
Well, mine didn't either because I actually looked that code up today and thought I was looking at 0.655.
Okay. Paragraph starting on the bottom there. Oh, we haven't addressed that footnote down below.
The only question I have is the wording in this finding must presumably
No.
refer.
Presumably refers to rather than must. Is that what you're getting at?
Well, I just, must presumably, I guess,
I don't like the word must in there.
yeah, I guess I just didn't understand what it does, but what it
Presumably.
So I take out must and it says in
Presumably
this finding
refers.
presumably refers to the
Yes,
large.
correct.
Reads better.
Reads better. But thank you for adding that footnote, Julia. I think that makes it clear. Okay, last 3 lines on page 4, and then continuing top of page 5. Should that be in here? I have the same concern about the next paragraph. We are not in the findings yet, and it does not relate to the Superior Court order. So, what's the value of having those 2 paragraphs here? Are they necessary?
I guess if anything, I mean, it is a nice preamble to our findings. So I guess maybe the question is whether beginning with page 4, first full paragraph and reviewing P&Z resolution, that whole thing may possibly be a preamble to findings.
Well, I thought what you were talking about last night is as you go through and you're guided by the the decision talks about how you need to have this nexus. And so then what we were talking about last night is, okay, so now we're applying this nexus, and here's where,
Okay,
Right.
here's where we're guided by. So do we need some other kind of a bridge?
Yeah,
that-
maybe.
I think this will give the reviewer an idea of where we've
Where
been,
we're
and where we're
heading.
going.
that's true.
Yeah, I think it does that. I think it serves a useful purpose, so I think it
Okay.
belongs, and it's,
That's
I
fine.
guess the only question was your comment about whether this falls into the heading of review of the order. I guess that's
Yes.
the only question, is it in the right place? I
But-
think it's very valuable.
I think it's very valuable. I think it needs to be someplace. I'm just not sure that it should be there. But
Perhaps.
I don't think it hurts.
And then, see, we've changed from the resolution, and then we're talking in the context of the record. We're talking about findings and ultimate action.
Yeah,
So we're transitioning away from that, and then we transition into how they treated it during their deliberations,
yeah.
and how it was misused or misapplied.
Maybe
So-
you don't need the subheading, exactly.
I'm sorry?
Maybe you don't need the subheading.
The subheading meaning
Under number 1, maybe that's what, I mean, this is.
Introduction.
Yeah, introduction.
why don't we call it introduction?
Then it works.
Because that way, I think that, does that work with you?
Yes, sir.
Bob,
And then what I-
are you okay with that?
I think that's a good fix.
Then I think that
Yes.
where it says, in this new appeal by the Superior Courts, and I think that's where I have to put in case number, so we know what the Superior Court is. So I'll take that out of the heading and just stick it.
Yes,
That part
would you
down.
please?
Yep.
That's a good fix.
Yes. Okay, I'm fine with that. I think that fixes my problem with this whole thing. I would like to simply delete the sentence that says the Board of Adjustment makes the following findings and conclusions. I think it's superfluous. We don't need to say that. Any difficulty with that?
No.
Okay.
I do have a question in the
Yes.
paragraph just above 1, 2, 3, 4, 5th line, 4th and 5th line.
From the top?
From the top, from of further concern, go down to line 4.
Okay, 1,
Yes.
2, 3,
Where
4.
it
Yes.
Follows, because it was not adopted as regulation by either the planning department or the planning and zoning commission.
As a regulation, not in regulation. As a regulation.
As a
Oh,
regulation.
Does that make sense?
Well, my question is, neither of those have the authority to make regulations.
Yes, they do.
They
both
do, they do.
The planning department does as well.
Right.
Okay.
And they go through the assembly for the final phase.
Right, exactly.
Okay, so then the only change is we're changing in regulation to as. As a was not adopted as a
As a
regulation.
regulation.
Correct.
Yep.
Okay?
Thank you.
All right, we are now at Roman numeral 2 findings. Preamble is okay? Any problem? No?
Mm-mm.
Okay. Paragraph number 2. I would like to strike the words "the aggrieved parties with" and simply say the Planning and Zoning Commission provided an opportunity to articulate objections. Because it's not just aggrieved parties, I mean, there were some supporters too, so I think we should not label them.
So I guess the question is, we specifically articulate our objections. Well, a significant
Yes.
amount of the testimony was in support.
Yes.
As well, so
Right.
perhaps it's space, support or objections.
To articulate
Support or objections.
support or objections. Support and objections?
Sure, that works. Both
Any,
really well.
any heartburn over either one?
No, and
Doesn't make any
is good.
difference.
Okay, and objections. Number 3. Any problem with number 3? Mr. Stewart?
None.
Number 4. Any problem with number 4? Julie?
No.
Okay. Number 5 on page 6. Oh, we're zipping right along here. Number 5. Any problem with number 5?
None.
Julia?
Good.
Mr. Chair, if I may, at the very end of that paragraph, there's 2 sections. I suggest producing the proper citation, A, C sections.
Okay.
And then numbers.
Yes? Thank you. Number 6. By regulation. In regulation. Is that a
Adopted.
technical
That's the
term?
term, and is it adopted in regulation?
Okay, all right.
So we use-
That's like lawyers have special language. Municipality lawyers have a different language yet.
Let's ask.
No, it's perfectly fine. I'm really
Well,
sorry.
you changed the other one to in the one above there you've already changed 1 as a regulation, so that was okay. I mean, that
Okay,
in
well then,
context,
let's
so-
remain consistent as a regulation. If that tracks what we
Okay, let me
had
see,
said
where
before.
were we?
6. Number 7.
Just as a.
Yes, sir.
I'm wondering if, it says during all concerned, I think that's kind of floating out there without any interpretation of what that means. And I would suggest that maybe we just modify
I
by
did.
at the end adding words prior to and during the public hearing. Because the point is that, I think my point that I discussed is
Yes.
a lot of good happens before the public hearing. And the public hearing is where those issues that remain have to be settled, but good planning happens before.
Okay, so you want to add the words prior to and during the public hearing process? The public
Yes,
hearing?
that would be it.
Public hearing process?
Yes, that would be it.
Any other changes to number 7? Hearing none, we are going to number 8. That's an awkward sentence. Can we put this in the positive in some fashion?
Could simply say the application for limited site review in this case includes both exterior and interior renovations and alterations.
Yes, I think that's better.
Okay, so say that again.
The application will limit the site review, plan review in this case includes both
Includes both
interior and exterior
interior and exterior
renovations
renovation.
and alterations.
Much better, thank you. All right. Are we fine with that?
Yes.
Okay. Julia, you fine with
Good.
that? Okay. Number 9.
That's good.
I have a change on that.
Tell us.
I think this appeal was heard by the Board of Adjustment
Okay,
in accordance with it.
fine. Okay. Number 10. You're fine with that? I hope the citation is correct. I have
It
not
is.
checked, but
It is.
Is there any need?
Bob Stewart would have checked.
I did.
Thank you.
Is there any need in this sense to refer to the Superior Court order?
I don't think so. All right, we have a little typo here. The
Yes.
Roman numeral 3 and conclusions need to be moved in the middle. All right, let's look at paragraph 1. What we did, by the way, is we had previously numbered paragraphs consecutively. And I must tell you, it looked odd. And so what Julia and I decided, subject to your approval, to do was that we numbered the findings separately, the conclusions separately, and the decision separately. To make it a little clearer, so that,
Very clever.
you know, there are some of us, you know, who are
You're on top of your game when you came over that.
absolutely. And it was my suggestion. Anyway, come to paragraph 1 of the conclusion. Does findings need to be capitalized? Dean, you're the expert in this.
I couldn't say.
Okay. Anybody have any particular feelings about it one way or the other? Let's leave it.
Well, we capitalized it here as, and 2 as findings.
Okay. I mean, I have no
In this
heartburn one
case-
way or the other. If you would like to capitalize it, let's. Would you like to do that?
I would.
All right.
Absolutely.
It
Done.
matches.
Okay.
Okay, do you want it in all small caps, the way the title was done?
No, just a capital F. I think that'll be fine. Barbara, are you tracking this?
No, sir, I'm not. Are you ready for me to take dictation?
All
I
right.
guess,
No, the reason I'm asking Barbara is because you said before you were going to track some of these things
Oh,
as we
yes.
are discussing. So I didn't mean to
Okay.
imply that you
I
need
had,
to do it.
it's,
Yes.
do I, so I'm wondering if there's a grammatical error there. Now that you brought attention to it, the Board of Adjustment concludes on the basis of its capital F findings that the planning and zoning resolution is insufficient. Okay.
What's your concern?
My concern is that it makes it look like you're pointing to a particular finding when you capitalize it that way. Which you're not. You're saying on the basis of the finding you're concluding.
Yeah.
So maybe I need to put on the basis of its findings, the Board of Adjustment concludes that the.
Yes, I think that's a better way of doing it. I agree.
And then it won't look so
Yes.
odd to have a capital F in the middle of the sentence.
Okay.
It's like that dangling participle problem with
Yeah.
that, you know, I just.
You know,
all of
my
a sudden
wife,
I
the
saw-
English
This is
teacher,
better.
would have immediately caught that.
Yeah.
Thank you.
So it's really Bob, if I hadn't.
Okay. Anything regarding paragraph 1 that we need to add? No? Okay. Number 2. Do we need to say again, the Board of Adjustment concludes? Or should we simply say, Planning and Zoning Commission members were misinformed on certain legal standards material to the case?
That works. Okay.
Julia?
I like it. I'd
Okay.
like to take out the Board of Adjustment concludes that, to start with planning and zoning.
Should members be capitalized?
No.
No. Number 3. I had something here. Number 3. Here, the second sentence I would like to change slightly. Furthermore, you already identified the memoranda. So wouldn't it sound a little better if we simply say, furthermore, in reliance on that memorandum, the Planning and Zoning Commission has misapplied material provisions of the code?
Okay, and do I capitalize memorandum?
Yes, most definitely.
And I take out the dated things?
Yes. Because we already identified the memorandum. Agreed?
Yeah, it's in the same paragraph.
Yeah, okay. Let's turn to page 7. Dean, are you okay with that? Would you please speak up when you have some changes that you're suggesting?
I'm not.
Okay. Number 4. Can we leave out the Board of Adjustment concludes that and simply start the sentence with the deficiency in the record regarding the relationship, etc., etc., pertains to issues material to the decision in the case. Board is not in a position to remedy the deficiency.
I have those first things taken out. Do you want us, do I read in the Board of Adjustment in the second sentence?
Yes, I think
Okay.
that needs to remain.
Okay, thanks.
Does that make sense?
Yes.
Are we in agreement? Okay.
Yeah.
Number 4, decision. Paragraph 1. And let me tell you why I suggested to Julia that we change this. We previously had that first paragraph in the conclusion, but it's not really a conclusion, it's our decision. Our decision is to remand the case. So it's not a
Yes.
conclusion. Okay, and so for that reason,
Right.
I suggested a section that's called decision, and that's what our first decision is. Does it make sense?
It
Good.
does.
Thank you. Okay, next paragraph.
I guess one question. The Board of Adjustment remands the case to the Planning and Zoning Commission for decision. Finds the code in the Board of Adjustments, capitalized findings, capitalized conclusions, capitalized corrections.
And,
So should that be findings, conclusions, and decision?
and these findings. No?
That'd be fine.
Is that,
Because
do you feel that
This
sounds better?
This sounds like these are,
Right, I think what he's saying is we substitute the word decision for directions.
yeah, or with this, yeah. But just if we say findings, that's an article. conclusions or open directions is not. So
Okay,
however we handle it, I think we need to be true to that.
and the boards. And these findings, conclusions, and decision.
Right.
Is that,
I don't think you need the Ds, just do the board and board of, oh, you're saying take out board of adjustments and just put
yeah,
Ds?
because I already have to.
And Ds, okay,
yeah.
I get it. And Ds, findings, conclusion, and decision.
Yeah,
Yeah, I love that.
I do too. Any problem with that?
No,
Bob? Okay.
not a problem.
Number 2.
Before, had we said matters of law,
No, we left.
independent judgment on legal issues, I guess that's the same thing.
That's, I think, the wording of the ordinance, isn't it?
Yeah, the word in the ordinance is legal issues, and it says legal issues includes construction of ordinances and things like that. One of the things that I suggested adding here
Yep.
Yeah.
is that in the, this is the envelope for why I'm suggesting that he added. The Board of Adjustment addressed the issues that were on appeal in their discussion of these things. I mean, this is what drove that. So I was thinking that this sentence could be changed to say, after the comma, after the case number, comma, and provides direction pursuant to 2130, 100. You don't need to have the as follows.
Okay.
And then add the sentence, the interpretation and construction construction of ordinances address several issues raised on appeal, or of law, I guess is what I have here. Construction of law addresses several issues raised on appeal, so that all the issues that are sort of in the appeal that you handled, that the board handled by these directives, are answered here. That sort of ties that in.
Try that sentence again. Instead of having a colon there,
Right.
you want to make a period
Right.
and then say,
The board's interpretation and construction of law addresses several issues raised on appeal.
the board's interpretation, and you mean the Board of Adjustment,
Yes, I need the board of adjustment.
interpretation and construction. Yes,
Of law addresses several issues raised on appeal.
So we're taking out the word ordinances,
Where is,
or was that,
I'm gonna look up the,
it uses interpretation and construction of ordinances and other law.
yeah, so, you could say that, of ordinances and law.
the board's interpretation and construction of law addresses several issues? No?
No, he was saying that that code site, which is 090B,
Yeah,
says interpretation, construction of ordinances and law. Is that what you're saying?
Ordinances or other provisions of law, and I just kind of shortcut it.
Yeah.
So I think it's keying on the
and
ordinances.
where do you want to stick that in? Relative to the new sentence?
Where I had law on the interpretation and construction of ordinances.
Of ordinances, okay.
And why I struggled myself with that was in my fine-tuned work here, ordinances are what the assembly passes, AO 2006, like that. And then we call what's already published in code as the code, but I think just sticking to what is in the code now is the best thing to do.
Okay, so the sentence that is added there, we strike as follows. First of all, we change the colon to a period, and then we say the board's interpretation and construction of ordinances addresses several issues raised on appeal. Colon.
Yeah, I would just stick with the other thing, ordinances and other provisions of law.
And other
I think that's a good fix because it addresses then the regulations and everything else.
provisions
In addition
of
to the code.
law. Okay. And then following the word appeal, we make the colon at that point.
If you want to, I
Yes?
think you have.
No? Any-
I think that the colon would follow right there because we took it away from 100.
Yeah. So you want to put it back in there at the
I
end?
think-
Or do you want to leave it off?
I
It
don't
makes
think it
no
calls
difference.
for colon anymore.
Okay, all right, so we leave the colon out,
Right.
make a period. And then we have capital A. Please look at that.
I like the way those are all combined.
I'm sorry?
I like the way those are all combined
Okay.
in one statement.
Should there be a comma after solutions? Before where? Wish my wife were.
I don't think it calls for
Okay,
it.
Is it, did you mean
It
to
makes a
put
long sentence.
per in there?
I
Is that-
did mean per, because
Okay.
that's what that code tells you to do, is to look at that with those other 5 considerations, remember?
Okay, yeah, it does. Okay.
are you
Okay, so
suggesting a
that could
change?
have-
Are you?
No, that works.
The way it is right now. Okay. Any other suggestions, comments regarding?
I'm gonna
2A.
look over your comma question again slowly.
No, forget it.
I just have to read, I'm just such a slow reader, the essentials. No, I don't think it needs a comma.
Good. Disregard my comment. Capital B,
I had-
preamble.
I had a suggestion.
Let's just read it first. All right, we're dealing with the first sentence of B. Bob,
Okay.
Julia,
I had a suggestion. And my suggestion is to add a footnote. And the footnote that I'm thinking of is that in the record on page 120, there was this paragraph, and so this is part of the public, it's written public testimony instead of verbal public testimony. But rarely have I seen an explanation that was so articulate. And it says this: it is unreasonable to interpret the code's 10% of project cost provision as a limit on the Commission's power to enforce standards that apply to all site plan approvals by code. That interpretation would mean that the property owner could be allowed to modify the LRE in a way that severely increased the degree of its nonconformity with the code standards, so long as the property owner spent a small amount of money mitigating that problem to some small degree. And that to me was the key
Yes.
to understanding that paragraph. So, to understanding the whole thing.
I think that's a good idea.
And so I would suggest that the footnote come at the end of that
Preamble.
sentence, and it says the board, if this is true, the board is persuaded that, and then just give the quote and put the record.
Yes.
Citation. Because that's really what
Yes.
you spent your time talking about. In balancing that 10% against.
All right, so the sentence reads, "The board is persuaded of the correctness of
Well,
the
just, I would
statement."
just say is persuaded that, and then just give the quote.
That, okay. Dot, dot, dot.
And then that
Page
ties your
120.
decision into the record too.
Yes. Are we in agreement on that?
Yes.
Okay, done. The little paragraph 1. First of all, there are periods behind those brackets there. We should have either a bracket or a period, but not both.
Oh,
So take those off, would you please?
okay, so I'm gonna take the period off.
Yes.
Oh. Okay.
Okay, so we come to number 1. Required to maintain conformity with code. Any problem with statement number 1?
I don't have any.
Julia?
Did you want me to put a semicolon between 320 and 200,
Yes.
as you had asked?
Yes,
before?
please. And following 200 as well. Number 2. Here is my concern about the term of the use of the term grandfather. Grandfather has a particular meaning which refers to a non-conforming structure.
No, we're
Remember,
talking about-
this is not a non-conforming structure.
we're
This
talking
is a
about-
conforming structure as of
It's
As
treated
of
as
May 8th.
conforming.
It is treated as a conforming structure.
I think that the chair is mistaken in thinking that a grandfather project is a term of art in the context of non-conforming structures. I believe that a grandfather project, as Dwayne and I talked with the board about last night, a grandfather project is separate and distinct from a non-conforming project.
Okay.
A non-conforming project isn't grandfathered in. And it has to, and any change they make for it has to be brought up. A grandfather project, on the other hand, is one that's deemed approved.
Deemed approved. You are absolutely correct, and I stand corrected. Okay, fine. That
But
was
maybe we
easy.
need to put a footnote to say what that is, so that we don't stumble on that.
Well,
If
That's
he
a-
raised it, then somebody
That's a
higher up the line
possibility,
might
yes.
have
Yeah,
the
I
same
mean,
thing,
that's-
so that
yeah.
that analysis should be in there.
So, just as a point of reference, if you go to 2155-130, go to the enumerated 5 conditions, 5 specifically addresses that issue. And to read it, it states, to grandfather existing large retail establishments and to set standards for the renovation which encourage conforming to the new standard or new ordinance without any.
Let me show
So-
you my copy.
No, that's fine.
So that-
So should we simply say C and then make the statutory reference? Is that,
I think that would be a good idea, so that
Okay.
it doesn't get stumbled off of that. So can I just, do you want to do it there, or do you want me to do a footnote?
yeah, make a footnote. C, AMC, or last sentence.
Well,
Whatever it is,
It's 5, yeah,
identify.
so it's C-A-M-C, 21, 55, 130, now we have to put the A, dot 5,
Capital A, little a,
that, capital A, dot 5.
A.5. Okay, I think that's fine. That clarifies it.
That works.
Works for me. Bob, does it work
Yes.
for you?
Yes.
Okay, Julia? All right. Dean, any question?
No, I think that's a good idea.
Thank you.
Thank you for asking.
Go to number 3. So here you have a comma.
On that paragraph,
Yeah.
suggestion, at the end it says to allow new remodel renovation without the potential burden of pre-existing site plan issues. I think it might be clear if we said potential financial burden of resolving all pre-existing site plan issues.
Potential financial
Burden
Of
of resolving all pre-existing site plan issues.
Oh, thank you for that addition. And while we are at it, footnote 3 needs to be changed to footnote 6. Anything else regarding number 3?
I think that's a good fix.
I
like
think
that.
it is. Thank you. Number 4. And look also at the footnote down below, which is labeled footnote 4, but should be footnote 7. Any discussion regarding number 4? I'm fine with it. Dwayne? Julia?
I'm good, and what I'm gonna do, the machine does automatically number footnotes, and so I'm gonna
Okay,
insert the
whatever.
footnotes, and I'm gonna leave that to the machine to do
Okay.
consecutively, so I don't get wrapped around.
All right, now let's go to capital C. It should say enumerated at the end of the first line.
Thank you, you doing that one, and
It's okay.
the D.
And it should say AMC 21, 55, 130.
And it should say R. Provide.
End of the last sentence.
Oh, the intent.
The intent
still
is,
okay.
so you,
I
it's
struggled
okay.
over that last night. So we don't change it.
Should we cite to the record specifically in the parenthesis?
It would make it easier to review.
Is the backsliding in the record or in the brief?
It's,
Or, I mean, you mean to cite to the brief?
I think that's where it first came up. Both the appellant's brief and the appellee's brief refer to backsliding.
I think the first reference as I see in the appellant's brief, it's page 5 of 22, halfway down.
Okay. On page 5?
Page, appellant's brief, page 5.
Oh, in the first paragraph. Yeah.
Middle. It's first place he has it in quotes, so I expect it's.
Okay, there's,
So refer to that, and it is also referred to in the appellee's brief on page 14. Oh, and the appellee's brief also cites the appellant's brief right there on page 14. So why don't we simply do this by way of suggestion that we refer both to the appellant's brief, page 14, at 14, and to the appellee's brief, which by coincidence is also at 14.
the appellant's
Well-
brief is at 5.
Correct. Appellant's is 5.
Well, but here's what the appellee says. See appellant's brief at 14. In other words, there can be no backsliding by the deemed approved LRE with respect to the standards. AMC 2155-130.
Important thing is we get it in so that they can figure out what the issue is, either one.
I have no heartburn one way or the other, so.
Right, so
But I think
so
we
I
need-
do see it where it's on the appellant's brief, so I'm gonna put appellant's brief 5, semicolon 14. And then appellee's brief 14, and there's probably something else
And
in the
the-
appellant's reply brief.
It is. It is also in the reply brief.
It's that transcript, page 61 and 62.
So the appellant's reply brief, they have a whole section on page 2 of the reply brief.
So,
That addresses, does oppose allow backsliding. So,
I think it is important if we quote the appellant's brief that we also quote the appellee's brief, because we are siding with the appellant in this, on this particular issue.
Right, so I got it, I got appellee's brief.
Yeah, I think
It's
she's
Good.
got
So make sure that you
And the
cover both of
transcript,
them.
I think it's good to have the transcript.
Okay. All right, so getting back to paragraph C, page 8, and the stuff in parentheses, first of all, the bracket needs to be moved over a little.
It's probably a function of making sure that the
Okay.
paragraph is justified.
Okay, so
So,
we add following the no backsliding,
inside the bracket we have,
yeah,
is that what you want me to do?
no,
Oh,
no,
just a
simply
reference.
refer to the
Okay,
record.
reference.
Okay, reference
Not a-
record. Okay?
And do those references go inside the
Yes.
parentheses? Okay.
Yes. Does that work for you? Okay,
That's fine.
done. Look at capital D. discussion necessary regarding that paragraph?
I think that it's probably not so accurate, it may be less than accurate to say in the application, and just say that, i.e. the assertion that proposed site plan changes violate restricted covenants.
Okay. Yes.
Among the parties and others.
Yeah.
Right. Anything else? No?
Nope.
Okay. All right. Before we make a motion to approve the Board of Adjustment findings, conclusions, and decisions as discussed tonight, Julia reminded me that what we failed to do the other day is that we need a motion for that we have substituted our own judgment in the interpretation of certain ordinances, and that is specifically authorized by AMC 090B. And that's what we have done, both in terms of the findings and in terms of the, that's what we call here, the directives. So I would move that those conclusions and the direction that we are giving planning and zoning constitute our own judgment of the law as authorized by AMC 21-030-190B. May I have a second, please?
Second.
Okay, Mr. Adams seconds that. This is a housekeeping measure. It's clear to us that we discussed ordinances and applied our own interpretation. I think it needs to be clear in the record for anyone reviewing this that we did this pursuant to the authorization given to us by code.
Right, and it said, the code says that the code says that that notwithstanding provisions of a different subsection, the Board of Adjustment may, by an affirmative vote of 2/3 of the fully constituted board, substitute its independent judgment for that of the lower administrative body on any disputed issues or findings of fact. And so that's one that's a little bit different, that you're not, that's not the one that I believe that you're
That I'm referring to?
right. And that's in a different section, so that's why it's section B, and I'm just not quite sure if the B part came out when we were talking.
So what are you suggesting?
Nothing, I just wanted to make sure that you're going under AMC 21-30-090B.
We did, and I
Yeah.
specifically addressed that.
Yeah.
Okay. Dwayne? Any further discussion regarding the motion?
No, I think it states for the record what our intent was, what we did, what our process was.
Okay,
Those were the rules we operated.
thank you. Bob, anything further?
No, I think we've left a good track record for review.
Okay. Barbara, would you call the roll on the
Yes.
motion?
Mr. Guchow?
Yes,
Mr. Stewart?
Yes.
Mr. Adams?
Yes.
and the record should reflect that the motion passed 3-0.
And then
Yes?
a corollary housekeeping occurs to me because on page, if you look at page 5, when you're going through the findings, it says after reviewing the record before the Board of Adjustment in appeal following the remand, the Board of Adjustment finds by unanimous vote. And so,
Yeah.
On these, there were several that you did by painstakingly, by formal vote. And then subsequently, last night without formal vote, as part of the working group, you asked that some be moved, additional findings of fact be, moved. And so, moved in the drafting up to findings, but I'm not sure that it's totally complete that way, because you passed 3 findings and by separate motions. So my suggestion would be that when you go through to do the final adoption, that you're specific enough to incorporate, because you've now got a decision as the findings, conclusions, and decision, and then that'll be by the vote, and then this statement will be correct. Do you
Okay.
understand what I'm saying? I don't think so.
I think I do, and I will, anything further before we make the motion to adopt what we've done here? Any further comments, suggestions? Seeing none, I will then simply move that the Board of Adjustment adopt the findings, conclusions, and the decision contained in the draft, and approve specifically what has been stated there as findings, conclusions, and decision. And the introduction. All right. Okay, Mr. Adams will second that. Thank you. I think we are at the end here. As I have stated before, assuming we approve this, the changes that we have discussed here tonight and that we have approved will be incorporated in the final draft that Barbara will prepare sometime next week.
Yes.
And she will simply call me and say, come over and sign, and I will then sign that. Okay? If there's any change, any confusion, any issue, we will have to come back together. But it is my intention to simply sign what we have approved here tonight. Dean.
Mr. Chair, I was reading here on the Board of Adjustments appeal process. Section 213095 about decisions says there should be some language. So I think it's sort of a housekeeping matter, but right before the passage of the approved sentence at the end of this decision document, I think there needs to be some statements that it's a final decision, there's these.
No.
There's language in the code.
This is not a final decision because it's a remand. So there is no appeal.
I think though, even when it's not final, it's the language that needs to be there. Do you have the code with you?
I do. Go ahead and tell me what you're
So
looking at.
in
Because we didn't.
We just-
D,
Well, give us the statutory reference again.
213095.
21.
It's not final.
213095. You need to give me a minute here to go to it.
That's only. Okay, maybe withdraw that comment there.
Right, he's just withdrawing the comment.
Oh, okay.
He's with us now.
Just for your information, just Dean, it's okay. Don't worry about it. I can tell you that Julia and I talked about it, and because we were discussing exactly that. Do we need to have any further statements as we usually do? And the answer we came to was no, because it's not a final decision. We don't need to do it. The whole purpose for adding the final decision paragraph is to alert parties that appeal from this board is directly to Superior Court. That's the purpose for adding that statement. And we don't need to do that in this case. So that's the conclusion that we came to. Does that engender any further discussion here
No.
by my fellow board members?
That's what subsection D says in the very beginning.
Okay.
So, to me, the only rationale at this point of including a sentence that says pursuant to 2130.095D, this decision to remand is not a final decision, would be to be clear to any party who may not understand the code and who would want to bring this up as an immediate thing to Superior Court. So adding although not required, but adding a reference to code may be easier here than it would be to have to defend an improperly filed Superior Court appeal of the decision. So that's the concern that I have. That in terms of Dean also questioning that makes me think that maybe, just like with the chair's situation with grandfather, that we decided to go ahead.
This is not a provision that I was familiar with. I just glossed over it. I wasn't concerned with it. So, and now that I see it, I think that's probably a good thing to bring it up.
If you want to, I disagree, but if you want to bring it up, I'm perfectly fine with it. I don't think it's necessary, but if you would like to add it, let's add it.
I don't believe it's necessary either. I'm just concerned now that
And what you're referring to is a statement that says this is not a final decision of the board.
yes, sir.
And leave it at that, just one sentence,
Well, I would
one
just
line.
say in reference, I would reference the code.
This is not a final decision of the Board of Adjustment, period. AMC 2130.095, capital D.
Yes, that would alert everybody that when they read it.
So would you like to add that? If you want to, that's fine by me. I don't have any heartburn. I don't think it's necessary, but it's fine.
Well, I think we've tried to make the record clear for anybody that would read it as to how, what, or why we
Okay.
did what we did, and this helps explain that.
All right, so it should be capital E on page 8.
I don't think that it's a directive. and so
No,
I think-
it's not a directive, that's true.
And so I think that, as Dean was saying, that it would just be another paragraph,
Yes,
an
exactly.
unnumbered paragraph.
Oh, in number 3, we have 1, 2. Okay, so it should be a 3. This is,
And I would prefer just to quote the code.
no, we're not adding a whole section here.
It's not a whole section, it's one sentence.
This is not a final decision of the,
It is a final decision of the Board of Adjustment. That's not the point. The point is, it is a final decision with respect to any issues involved.
On the remand.
Yeah. or wherever that is. So I mean, that's why I just think that you want to, the point is to prevent interlocutory appeals when you don't have a final decision. So, Dean, what language, you had some language that you were thinking of. What did you have?
I actually like simplicity of the sentence in which this is not a final decision of the Board of Adjustment, the citation.
Okay.
I think that works very well.
Okay.
I'm sorry, I also thought, although I think that works well, I was thinking, this is a decision is issued pursuant to co-section. Instead of saying on final decision. So like it's sequence, yeah.
And which one would you say that it was issued pursuant to?
This decision is issued pursuant to AUC 2130-095. So don't say.
Okay, rather than saying this is not a final decision, simply say this is a decision
This decision is issued pursuant
to.
AMC
Yeah.
21, 30, 5.
This is a decision of the Board of Adjustment pursuant to AMC 2150-090.
095
095D.
and 095D and AMC for 2130-100. And so I'm asking Dean, and AMC 2130-100.
Okay,
Or not? I'm asking him, because he mentioned that 100.
I didn't, but I think it fits very well. Because we're seeing a remedy down.
agree. Are we all on track here? Don't be so quiet about this. Pipe up.
I'm going to need about a 3-minute break here, please.
No, we are almost done. All right, so I will move that we supplement our previous motion to adopt the introduction, the findings, conclusions, and decisions by the sentence that we have just been discussing. Bob, second?
Second.
All right. We have discussed this. It is a sentence that everybody feels apparently that it adds something. It's fine by me. I intend to vote for the motion.
I think it helps clarify and it will point people to this provision to read why we did what we did.
Okay.
So I'm going to
Barbara?
approve it.
Mr. Goodchow,
Yes.
Mr. Stewart,
Yes.
Mr. Adams.
Thank you. The motion passes 3-0. All right. We are now at the end of this case. And before we adjourn here, yes, Barbara, do you have something very quickly?
Yes, I have something very quick and very important. You did make one motion to adopt the conclusions, but you did not vote on the interim motion. The Board of Adjustment adopts the findings, conclusions, and decisions and approves specifically what was discussed. You didn't vote on that one. That this was all discussion of that.
So why don't you go ahead and re-vote so we can move on?
Just re-vote on
Yeah,
this.
it's not
That's fine.
emergency. Have we voted on this
Yes.
as a whole?
Yes.
Well, you have not. In my
I don't think
notes,
we
you
have.
have not.
I thought that's the motion that I made.
You did. You made the motion and then okay.
Okay.
Your last motion was a motion to supplement the decision.
Yes.
With a sentence, but you never voted on the decision.
Okay,
Yeah,
let's
supplement.
quickly,
I believe that's true.
okay. So the motion should read, we are.
Good catch.
We are, I thought we did, quite frankly, but it's okay. I make the motion that we approve the Board of Adjustment findings, conclusions, and decisions as amended and as supplemented.
And introduction.
And the introduction. Okay.
Okay.
And Mr. Adams is seconding that,
Yes.
and there's no further discussion necessary. Barbara?
Okay, Mr. Guchow?
Yes?
Mr. Stewart?
Yes.
Mr. Adams?
Yes.
Thank you. The motion passes 3-0.
Good catch.
Before we adjourn, our esteemed council is leaving tonight, and I want to thank her on behalf of the entire board for terrific service that you have rendered to us for a number of years. And we wish you all the best in whatever you may be doing next.
Thank you.
All right. Anything further for the good of the order?
I have one more thing.
What's that?
Well, I think Mr. Stewart may have had something too.
No, you go ahead.
Oh, I wanted to follow up with the board on something that I brought up yesterday evening concerning the potential for ex-party contact. And so, as it turns out, I will report to the board that I had a voicemail yesterday from the Davis Wright Tremaine law firm, which asked me to call one or both of two attorneys identified in that voicemail about this case. Now, for lots of reasons, I didn't even get that voicemail or didn't even see it until today. And of course, I didn't call them back yesterday because I didn't see it today, and I looked it anyway. But that led me to look in my email further on what I had mentioned yesterday. So what happened, as best as I can tell, is that because this board is represented by counsel, me, the law firm of Davis Wright Tremaine sent a letter to the board, or sent a letter addressed to the board members by email to my email box, which I only opened as far as to see that it was sent to you, and I don't know the content, and I don't intend to look at that. And then in response to that, there was another email from Mr. Reeves, who apparently was taking umbrance with that letter, and I guess his email was sent to that people in that law firm, but copied to me. So what I had seen yesterday and reported to this board was this blip that came through that said blah 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 blah, and I didn't have time to read it. So I don't think that the contact to the board went directly to you, because you're represented by counsel, and there's a bar code violation against contacting, or at least not against it, at least significantly discourages contacting parties when they're represented, even though you're not an opposing party to them. As Dean and I are both aware of, not only do you have the ex-party contact, but you're not to consider the ex-party contact rule. You're not to consider anything outside the evidence that's brought on appeal. So you will not be. I will not be delivering that letter to you. And I have sent copies to Dean, and I'm leaving that piece of the puzzle in Dean's hands, and he can dispose of it as he sees fit.
Yes, 10 lashes with a whip to the lawyers. I think that is highly inappropriate, and I think your response not to bring it to our attention was perfectly appropriate. Okay, anything further we need to discuss? Seeing none, thank you very much, and we are adjourned.